When talking about probate, often what comes to mind, and the first thing actually mentioned in this chapter of the textbook, are famous celebrity cases revolving around deceased celebrities' fortune, who that fortune has been left to, and the legal battle that ensues. Examples include Anna Nicole Smith, Thomas Kincaid, James Brown, Gary Coleman, and Michael Jackson, to name a few. In this chapter, we will define, distinguish, and discuss what probate is and the steps involved, the difference between per stirpes and per capita distribution, the difference between intestate and testate distribution, what makes a will valid, the grounds for contesting the will, what a personal representative is and what their obligations are, what, if any, rights a surviving spouse has, whether or not someone who is responsible for death of the deceased can still be a beneficiary of their estate, and is an oral will valid. While we often think of probate in terms of large celebrity fortunes and scandal, the reality is that at one point or another, everyone will have some sort of experience with the probate system. Probate is a process of paying creditors and distributing the estate of one who is deceased. A person's estate can be described or defined as their net worth. This definition can be somewhat misleading, as probate courts also deal with issues regarding guardianship. Guardianship is the assignment of one who has the legal responsibility to care for the welfare of another as ordered by a court. Examples include incapacitated adults, minors in need of adult supervision, or those with no parents. Assigned when an adult is unable to manage their own affairs for any reason that severely limits their mental capacity. The probate court has the function or responsibility to assign the task of administering the estates of those who are deceased and those who are under legal guardianship. Whatever the case, the court steps in when a party can no longer be responsible for their own legal issues. Importance of probate courts and guardianship example from the text is once a youth is mentally disabled, reaches the age of maturity, and has not been declared legally incompetent, and then enters into a legal binding agreement or situation, that young person will be held liable for meeting the terms of the agreement. Intestate is defined as dying without a valid will. A will is a recognized legal document that allows an individual to dispose of their estate according to their personal wishes. We will talk more about what makes a will valid later in the video. Pitfalls of dying without a valid will include not having your final wishes carried out, and large amount of court involvement in distributing your assets. When a person dies intestate, their assets are then divided out using what is called intestate succession, where the state determines who will obtain the assets of the deceased. Two different methods can be used: per capita, which is seldom used anymore, or per stirpes distribution. In per capita distribution, all living relatives of the deceased are identified. Any assets that remain after probate are split equally among the living relatives. For example, say you have 5 kids, 2 aunts, and 7 grandchildren living, and you die intestate. The remainder of your assets after probate will be divided equally to 14 equal shares. In per stirpes distribution, all surviving family members are again identified. This time, however, the entitlement and the percentage of the estate you receive depends on the proximity of your relationship to the deceased. For example, say you are a widow or widower with 5 kids, 2 aunts, and 7 grandchildren. Because you have no surviving spouse, your children are entitled to the entire estate because they are your direct descendants. Generally, the spouse of the deceased is entitled to the estate, but certain acts such as adultery, abandonment for an extended period of time, or other acts that allude to a discarding of the marital relationship, or a spouse who is divorced from the deceased cannot inherit by intestate succession. The law finds that if someone unlawfully and intentionally kills the deceased, that person, the killer, will be passed over as if they preceded the deceased, and they will receive no part of the estate. The preferred method of probate is known as testate, the person having died with a valid will. As previously stated, a valid will allows an individual to dispose of their estate according to their personal wishes. The majority of states require a written will. However, some states do permit oral wills. If a state does allow an oral will, it has to be shown that at the time of the oral will, the deceased believed death to be imminent, and the person who witnessed the terms of the will does not stand to inherit anything. For a written will to be valid, the testator, the person whose personal wishes are being recorded, must sign the will in full knowledge that the instrument being signed is a declaration of intent for the distribution of assets upon their death. The testator must have the capacity to issue the will. In other words, they must understand the extent and value of the estate and the effects of the will, the giving of the estate to specified others upon death. Finally, the will must be witnessed, which verifies the will was signed voluntarily by the testator. In the event a will is found to be invalid, the estate will be distributed by the intestate succession. Wills can also contain several components, such as incorporation by reference, which means that other documents listed in the will and the intent of those documents make them a part of a person's will, as if they were actually a physical part of the will. For example, parents who want to create a trust fund for their child fall into an incorporation by reference. Conditions may also be placed on bequest under a will. If these certain conditions are not met, that particular portion of the will is considered ineffective and inheritance will not occur. An example of this can be seen in the movie The Ultimate Gift, where a grandson must meet conditions in order to inherit his grandfather's fortune. When it comes to disinheritance, the testator is permitted to disinherit anyone with the exception of their spouse. Under state law, a spouse is entitled to a portion of the estate unless one of the circumstances of misconduct mentioned previously exists at the time of the testator's death. Codicils and revocations. For many people, they create their wills long in advance before they ever eventually die, or actually die. For example, my mother-in-law's will is over 20 years old. She and her now deceased husband created it when they had children, and outlined who would receive custody of their children in the event something happened to them. Both children are now grown, and the will should be updated to include new assets such as property. Update the beneficiaries as previous beneficiary is deceased, and should state new and updated final wishes. To make these changes, a codicil could be made. A codicil is an addition to an existing will. The codicil must incorporate by reference the pre-existing will. If it does not, the codicil becomes the new will. A codicil must meet all of the requirements of a will, as it becomes part of the will for legal purposes. The revocation of a will is needed when a testator decides to change how they want to distribute their assets upon their death. When a new will is created, the old will is automatically revoked, as it no longer represents the wishes of a testator. A new will does not have to be written in order to revoke a will. A will can be revoked through a written document, or the testator can take steps to physically destroy the will. Will contest. Think back to all the celebrities we spoke of earlier: Anna Nicole Smith, Gary Coleman, James Brown, Michael Jackson. All these celebrities had something in common within a probate setting. For one reason or another, each person's will was contested with the probate court. The contest of a will is a challenge as of the validity of the will. Common grounds for will contest are mistakes, duress or improper influence, and fraud. In most situations, the person contesting the will has the burden of proof to establish the will is not valid. How probate actually works. Many states have adopted what is known as Uniform Probate Code, which has established identical probate standards and procedures and outlines the basic steps involved in probating an estate. Once a person dies, their assets, including bank accounts, stock, bonds, and other financial matters in the deceased's name, must end, and all accounts are frozen until determination is made on the estate. The first step is the filing of proper documents with the court, including the will and affidavits from witnesses to the will. If no will exists, a petition is filed for probate of an intestate estate. Before any further steps can be taken in regards to probate, the determination must be made of whether or not the will is valid and if there are any challenges to the will. Once these challenges have been decided, the court then decides whether to probate the estate as testate or intestate. From there, someone is appointed to oversee the assets of the estate and is often called the administrator in the intestate estates or the executor in the testate cases. The responsibilities of the person including inventorying the assets of the estate, paying creditors as approved by the court, and protecting the estate until it has been distributed. Person has the obligation to care for the estates and not use or convert them from personal use or to waste them. Once an executor or administrator has been appointed and assets have been inventoried, it is then required to process any debts or credits of the deceased. Creditors are given a specific amount of time to file claims against the estate and must file appropriate forms with the court which document the amount and nature of the claim. Furthermore, administrators or executors can challenge the claim, and the hearing would be needed to determine whether or not it should be paid by the estate. Once the deadline has passed for filing claims, the probate court then considers all requests sent by creditors and arrangements are made for the payment of the claims out of the assets of the estate. After all creditors have been paid, the option is then given by most states for spouses to accept what they are entitled to under the will, or by claiming what is known as a forced or elected share, which is the right of a spouse to receive a statutorily designated percentage of a deceased spouse's estate. Once all creditors' claims and the spousal claims have been addressed, the court then proceeds to distribute the estate according to the terms of the will, should one exist. When a will does not exist, the common practice is to reduce or sell the assets and distribute them accordingly. To summarize the role of the probate courts, the ultimate goal of responsibility is to ensure that any debts a person has upon their death are paid and that their remaining assets are distributed properly. Thank you. When talking about probate, often what comes to mind, and the first thing actually mentioned, sorry, we're gonna have bloopers. When talking about the profile, is and the steps involved, the difference between per stirpes and per capita distribution. Herpes. Get out here. Come here. We gotta look up on our phone to make sure that's how you say that word. Because I'm telling you one thing right now. I can see all these people laughing like stirpes. That is not how you say that.